And I'd like to call the meeting of the Advisory Board of Speech Language Pathologists and Audiologists to order. Welcome, everyone, and I think everyone should have an agenda. We'll be able to see what we're doing. I'm going to start with the roll call today. We have a few absences, so let's just be sure who is here. Emmanuel Bodner.
Yes, present.
Patricia Brannon.
Present.
Chevelle Bryant.
Present.
Dr. Tammy Camp has asked to be excused today. Carl Hummel has asked to be excused today. And Dr. Robert Novak has asked to be excused today as well. Kristen Plummer, Michelle Tejada.
Present.
Okay. We do have a quorum. So, do we have introductions that we need to make, Mary? Anybody?
Not today, not today.
Nobody particular. So the next item on our agenda is approval of the minutes from our February 24th, 2016 meeting. I would entertain a motion to approve those minutes as distributed.
I move that we approve the minutes from the February 24th meeting.
Moved by Chevelle Bryant. Do I hear a second? Second by Kristen Plummer.
There was just one.
Discussion?
There was just one item. This is Manny Bodner. There was just one item that I had noted where the appointments of the staff members to the work groups are not noted. I've also learned there may be new staff assignments. So I don't know if there should be the addition as of these minutes were written, or if we should let that go until those staff assignments are confirmed or reconfirmed.
Mr. Bodner, we will have some new staff assignments, and we will note that today because we have some changes that I will announce in the executive report.
Well, then, just for clarification, would it be a more accurate reflection then of the minutes as of this date at least, that those members should be noted? And if they change today, then they'll change today. Again, it may be a point that is too detailed, but for the sake of accuracy, I'm curious if that's not a fair addition.
Oh, definitely. Do you?
May we revisit the minutes later in the meeting, and Mr. Bodner, I'll work with you to make sure that all of your changes are made to satisfaction on the first break. Is that okay?
It's fine with me.
Okay.
Thank you.
So we'll pass on.
Okay,
that
so
vote.
we'll hold on minutes until a little later during the meeting. And the next item on the agenda is public comment. So did we have anyone wishing to address the advisory board?
I don't think we received any forms.
Okay. Great. Moving along. The executive office reports.
Okay, my name is Mary Winston. I'll be giving the executive report today. Good afternoon, everyone. First announcement, which will go towards what Mr. Bodner was speaking of. Mr. Novak has had to resign his position. He's moving. He did want to be here today. It's going to be effective the 30th. And so we will have to post for that vacated position. So we did want to let you know that, and that will change some of the work group dynamic. Moving to item A, updates and discussions related to the transition transition is moving steadily along. Internally, we're working with DSHS staff on software conversions. We're also working with their licensing staff. Our licensing staff is working with their staff. And we're also hiring some of DSH staff and quite possibly more to come, because we want to make the transition as seamless as possible. Externally, we have completed recently our external strategic communication. I don't know that anyone of our board was able to attend the external strategic planning, but just to give you a definition of what it was, several members of our staff went to several cities in the state, and we asked the same question in every city. What are we doing well? What can we do better? And if you were king, queen, dictator for the day, what would you change? And over the next 5 years, what major changes do you see that will affect your business or the way that we all operate? The comments from the public that we did receive during those meetings is posted on our website. We also provided the same questions on our Facebook page, on Twitter, and we also have the answers or the responses from the public on our website from those methods of communication. I want to thank you all for working on work groups with all the rules. The commission approved your proposed rules, and so we're moving forward with that. And speaking of the commission, we have 2 new commissioners. 2 of our longtime commissioners have ended their service with us. That's Mr. Fred Moses and Ms. Luann Morgan. And we have been appointed, the governor has appointed 2 new commissioners, Mr. Rick Figueroa and Ms. Helen Collier. Internally, moving on to staff changes, the commission has accepted the resignation of Bill Kuntz, our executive director, effective August 31st of 2016. They have also selected Brian Francis as the new executive director of TDLR effective September 1. And it's a slight transition. We'll all miss Bill, but this change will not have a great effect because still same general leadership. We've been working along, and we don't anticipate that this will stop our progress as we move towards the October 3rd complete turnover date. That is my report today for Executive Office, and if you have any questions, I'll try to answer them. If not, we can move on to the next report.
Questions, anyone?
Okay.
Okay. So the compliance division is the next report on our agenda.
For the, Mary Winston again, for the compliance report, we did have a very short report, but I know the Director of Compliance is traveling today. And this couple of paragraph and a half here, couple of lines, it's just kind of notifying you of what I just spoke of in executive report that we have been hiring. I think a lot of you are familiar with Mr. Stephen Mills, and we are so happy to have Stephen to have accepted a position with TDLR. And he has a wealth of knowledge, and we can't wait for him to start, and his start date will be June 1st. Stephen and George will then start conducting interviews to fill the other 5 positions that will go into Compliance Division's Health Professions section. So we're steadily moving along in compliance as well, and that's the compliance report.
Okay, so Mary, are you representing education and an examination?
I am not.
Oh, okay.
We have Rebecca Armas coming to give us this report. She did such an outstanding job this morning. I'm going to email Ray Pizarro and say she needs a gold star and money. Welcome.
Good morning, Chairman and Advisory Board members. My name is Rebecca Armas. I'm with the Education and Examination Division. I just have a few things to go over with you. We just wanted to add a few new members to our team. We've added Frances Mendieta Pringle to our team. She is going to help us out in the examination and curriculum side, as well as from DSHS, Jerry Gonzalez. And he also brings to us a wealth of knowledge. He actually had a lot of dealings with the massage therapy program, so he'll be bringing over his expertise on that end. And in our report, we just kind of showed you a snapshot of our, it should read statistics for continuing education and not exams, since yours is a national exam. And also your continuing education is also nationally recognized. But we just kind of wanted to give you a snapshot of what our reports look like for those when we have to approve in-house some of the curriculums for continuing education and how many we do a month. This is, like I said, just a snapshot from our electrician statute. Other than that, I just wanted to say hello and welcome you to the TDLR family.
This is Patricia Brannon. So your responsibility also will be to update the jurisprudence exam?
Yes, 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 and we will be working on that with subject matter experts in the field.
When will that, we have a number of new rules, so.
Once everything is finalized, then we'll meet together, we'll put a call out. What the process works is, I'll put out an application on the listserv, and it'll be posted on the website as well, calling for subject matter experts in the field. And then we'll go through a process of selecting a small group. We'll probably narrow it down to about 10 or 15 people, bring them into Austin for a few days to go over this examination, come up with items that are relevant to the jurisprudence exam.
Will you have anyone from the advisory board as well? to
If
represent, or what?
advisory board members can apply, we just have to be careful that we don't have a quorum. Yes.
I was just checking, I was thinking that we had a work group related to that.
We
topic.
do have a work group.
Okay.
Mhm.
So
And that
we'll
can be
go
something
back.
that we can address during the work groups as well.
Okay, great. Yes, so there are people who've been assigned to that, so.
Yes.
I would think one person from that group might
Yes,
then
definitely.
participate, so we don't have the quorum issues. So.
Right.
Other questions about exams? I don't expect any, no, this is Sherry Sensiberian. I'm not expecting any big changes other than the jurisprudence needing to be updated.
Mhm.
People will still take the national exam.
Okay.
Sounds good, thank you.
Thank you.
And enforcement.
Good afternoon, board members. I'm Karen Cox. I'm one of the enforcement attorneys today, and I'll be giving your enforcement report. Our report is today in two sections. One is an introduction to the enforcement division, and it's a text description of the enforcement process. And the second section is staff report. It's key statistics. Future staff reports will look much more like this one. So at this point, our written reports contain a really good summary of everything that goes on, but if you have any questions, I'd be happy to answer them.
This is Sherry Sensiberian. I thought the report was helpful, but since we're switching to a different enforcement model, would you mind just briefly reviewing how enforcement works at TDLR, because I think it's a little different?
Happily. Enforcement at TDLR is, we get our cases from two broad categories. Typically, they're consumer complaints and complaints from within the agency. And consumer complaints are obvious. Those are people from the outside. Within the department, we get complaints from periodic inspections of regulated industries. Those come from field operations and from the efforts of our own investigators. If they're investigating another complaint and they find a violation of one of our other programs, they can open the complaint as well. There are also criminal history background checks which come from the licensing division. And those are initial applications or renewals where someone checks that they have had a recent conviction. And in fact, later on the agenda today, you have the new criminal conviction guidelines for your program. Or when we do a renewal and we do a routine check, we find that someone has a criminal conviction that falls within the guidelines, and those proceed to enforcement. The complaints go to the intake division. Intake does some initial investigation, including collecting documents, entering the complaint into our system. And they can close complaints if it is patently obvious that there's no jurisdiction. if we get a complaint that should go to another agency, for example, or it's something like my air conditioning costs too much, then those intake closes those. If they open them, they collect the information, and then it proceeds to an investigator, and the investigator, in most cases, it goes to an investigator. There's a small number of, well, they're not a small number total, but there is a number of cases where there are inspections that go directly to an enforcement attorney. The investigator, if it goes to investigation, contacts the parties, tries to, collects information, conducts interviews, writes a report, and then forwards it to enforcement. And then the enforcement prosecutors review the inspection report or the report from the attorney and decide, report from the investigator, and then decide whether it should be what's called a notice of alleged violation, which is the first step in a case that goes to a hearing. Whether it should be a warning letter or whether the case should be closed because of one of the reasons that we typically close cases. Closure is obvious. Warning letter, the case is closed with a warning because those are violations that we could think require some attention but don't need to go to the full fine and SOA treatment. In the case of a notice of alleged violation, the next step is then it's on the respondent, the person that we send the NOAV to. They can request a hearing, they can not respond, or they can settle the case. If they settle the case, that ends up, they pay a fine usually, and that results in an agreed order. The agreed order makes findings of fact and conclusions of law, and those agreed orders go to the executive director for signature. Almost all of those involve the payment of a penalty of some sort. Those cases are closed. If in some relatively small number of cases, the respondent is able to provide us evidence which indicates that the case should be closed and we don't proceed any further even after an NOAV. In the remaining cases, those are ones where they request a hearing, and that case is a small trial at the State Office of Administrative Hearings. We present our evidence, the respondent presents their evidence, and then the ALJ, administrative law judge, is the person employed by SOA, will write what's called a proposal for decision. And those proposals for decision go in front of the full Commission on Licensing and Regulation. And the commission will then hear arguments in a formal commission meeting, in a public meeting, subject to all the notice requirements of the Open Meetings Act. The enforcement attorney will put on a presentation, and the respondent may put on a presentation. Then the commission votes on the proposal for decision, and they can decide either to approve it or to reject it. And then once they do that, then the next step is there's motion for rehearing. If you're the respondent, if the department, we close the case afterward. But that's the long. Also, it's important to note that the department has the burden of proof at the SOA hearing. The standard is what's called, you would think after all these years I would be able to say this off the top of my head and not completely forget right now. It's 51% of the evidence. We have to present the preponderance, the technical word is the preponderance.
Yes.
That we have to present 51% of the evidence, and we present witnesses and documents to support our side of the case. If we win, we get a proposal for decision that recommends a penalty. Otherwise, we get a proposal for decision that does not. May I answer any questions at this time?
Okay, so Sherry Sabrina again. Here's the part that's so different that I'm not really sure how this is going to work. Under our old model, we had a complaints committee that was a subcommittee of the full board. Because some of the issues that come forward are standard of care issues. And so knowing that obviously you can't know standard of care for each of these health professions that you're about to regulate, what's the proposal? Do you bring in subject matter experts? Do you use some board members when it's a standard of care issue? And Kristen and I disagree about whether this was the appropriate hearing aid fitting, and I'm going to file a complaint on her.
Hi, I'm Christina Kaiser. I'm the director of the Enforcement Division. I'm going to help Karen with answering this question.
We do have a little bit of a different process because this board is now an advisory board. You are not a decision-making body any longer. We are not anticipating having a committee.
Right.
However, we definitely will need the expert advice from experts in the industry to help us decide on the standard of care type questions. What we anticipate is that in future meetings of the enforcement work group, that work group will help us figure out how that's going to work. One of the things the work group will have to help us with is figuring out where is this body of potential experts that we can call upon. Obviously, the advisory board members are one pool of potential experts, but we may encounter a case that where none of you would be appropriate because of a conflict of some sort. Ultimately, I think the biggest difference that I can, when I think about the current world as opposed to the way TDLR is going to handle complaints, we are looking for the expert for a very pointed and specific need. We need you to be an expert witness for us to help us understand the standards of care, but then the lawyers in the enforcement division are the ones who will make the ultimate decisions about once we have your evidence. We will be the ones that lay that evidence side by side with the law and decide what, if anything, was violated in the law, and then what penalty is going to be pursued. So that is something that, as I understand it, the board or the complaint committee of the board used to do. So that part of the process is going to be something that we do.
Staff.
But we definitely still need the expert testimony. And we'll need, whoever serves as an expert, we'll need that person to be a witness in the hearing if the case goes, to that hearing as Karen was describing.
Okay.
Just a couple of questions for clarification. My name is Manny Bochner, and we appreciate your clarifications here. You had mentioned the word, I think it's...
Mr. Botner?
Yes.
Can you get a little closer to the mic so we can...
Sure.
On YouTube?
You had made reference to SOA, and just for the sake of clarity, would you tell us what that means?
State Office of Administrative Hearings. It's the agency that employs the administrative law judges for all of the state administrative agencies
Okay.
for their contested case hearings.
The next just point of clarification, the example that we have a part of your report, this is specific to the Speech Language Pathologist and Audiologist Advisory Board. When you're talking about the performance, the key statistics, performance measures, sources of complaints, complaints by program, case outcome, so on and so forth.
Yeah.
This is real, this is not example, is that right?
This is all the programs we have combined right now. This is the entire enforcement division. This is all of our numbers
This
for
is
all of our
total.
programs. This is total.
Will we be receiving a specific report specific for this board?
Yes, typically what the reports contain is performance measures for the entire division, and then another section that's performance measures for the specific board in front of which the report is being presented. At this point, we don't have any numbers for this program, so we thought we would show you the numbers for the entire enforcement division.
So we'll just receive 2 versions of this eventually, or something like that.
One
right?
page with 2 sets of
Yeah.
numbers on it.
Okay, for our board and then overall. Great. Yeah, we would hope never to have 10,000 cases opened. That would be most of our licensees, so hopefully not.
Oh, that's okay.
Other questions for Karen? Okay. Are you coming back when we talk about the work group product?
No, I believe there are other people that are coming
Someone
back.
else? Okay. All right, thank you. Following your order. The licensing division, okay.
Good afternoon, Leonard Rivas with the Licensing Division. I'm the new Health Professions Manager. I also come from DSHS with 22 years of licensing experience. We will be hiring new staff members in the coming weeks to come over on October 1st with the new programs. We're currently going to the ACHS twice a week on Tuesday and Thursday to receive training on the programs that are coming to TDLR. That's all I have.
Okay.
Any questions?
Anyone have questions about licensing for Leonard?
No?
It's a
All
learning
right.
curve, right?
Yeah. Thanks. Thank you.
Thank you. And next on the agenda, Katie Bryce.
Hello, I'm Katie Bryce with DSHS. We held a recent complaints committee meeting, May 12th in Austin, and the next full board meeting has been moved from August 26th to July 8th in San Antonio. There will be no new business other than just signing outstanding agreed and payment orders to try to close as many things as possible before the transition. As Leonard just mentioned, TDLR staff is training 2 days a week with our current staff, and we're hoping that they will be fully up and ready by the time the transition starts to take over here. And right now we have 13,858 licensed speech language pathologists and interns. We have 4,509 licensed speech language pathology assistants, 1,300 licensed audiologists and audiology interns, 11 licensed audiology assistants, which gives us a total of 19,678 licensees currently. We have just had, I believe, our first application for an audiology assistant under the new rules that went into effect March 20th. So we're seeing an increase in that. So are there any other questions?
Sherry Sensibrian. So Katie, how many staff do you have right now? Or is it changed day to day?
It's changing. Right now, we currently still have the speech staff in licensing. There hasn't been a change in that. Some of the other programs have had changes. So we're staying steady right now.
So TDLR is going to help you process. I know you're hit with 500
Graduation.
graduates
Yes.
looking to be licensed right now.
Right.
And so hopefully.
Yes, I'll ask, when I go back, I'll ask Jennifer Collins, who's the supervisor, what the estimated processing time is right now, because I've been told that if we're starting to get behind, that we can call in licensing staff from other programs who aren't at a peak right now to try to get their help so that we can keep the time frame, within a reasonable amount of time. So, yes.
This is Manny Bodner again. So Katie, I'm intrigued with the Enforcement Division report. I really am. So if that information is not housed at TDLR at this point in time, I assume it's housed with you. That you must have that information that is particular for this board, this responsibility. Is
We
that
have-
a true assumption?
We have an enforcement unit and also an investigations unit that we all work together to handle the complaint cases currently.
Okay, so in other words, that if I were to ask you, if you would have the information, the number of cases open, the number of cases closed, and then just go down the line, the number of penalties assessed, penalties collected, particular to speech pathology and audiology, this is information that's readily available.
It is, and it's information I could provide you with. I don't have it with me, I didn't bring that, but it is information I can give you.
And then I would have to assume there's going to be some sort of a transition to get that information from your office into this office, so we can have somewhat of a comparison of where we're going, where we've been, and where we are, and where we're going to go.
Correct.
Is that also true?
Yes, Yes. At the last complaints committee meeting, we tried to review all of the open complaints that we had had a response to try to close out as many as possible before the transition so that we weren't just giving over a lot of cases that may not even need to be open. And we were able to close 15 of those cases. There were 5 that were tabled to come to TDLR just because they thought they were serious enough, potentially serious enough violations that they wanted to have the full resources at TDLR to look at those. I don't know what the actual transition will be since I'm not part of the enforcement at TDLR, but I'm sure that they have a plan in place for a smooth transition.
That was kind of my next question. Just as a reminder, when is the date of transition?
October 3rd.
October the 3rd, and so both before and after, we should see a lot of activity. Thank you.
Okay.
Sure.
Any other questions for Ms. Bryce?
Thank you.
Okay, at this time, we're going to take a short break so we can take a look at the minutes and see if we can include Mr. Bodner's request. So it's a good time to stretch your legs, go take care of business. We'll try to be back in about 5 minutes. one, you just never know, even if they're just. They actually didn't have someone that was licensing. And going to be over the health professions. We'll move them up a little bit. Oh, there we go. I think we're on. There we go. Yes. Shabal?
Yes, I move that
To
we.
accept the minutes?
Yep, accept the minutes.
Seconded by Kristen
I
Bonner.
second.
And any discussion now that the minutes have had the edit that Mr. Bodnar requested?
Yes, this is the set of minutes for clarification that Mr. Bodnar requested, so we are accepting the minutes as edited.
As edited, they now include the names of staff members assigned to be the contact persons for their work groups.
Thank you.
So, okay, so all in favor of accepting these edited minutes?
Aye.
Any opposed? Any abstentions? Motion carries. Thank you for making those changes. Say that. Okay, the next item on the agenda, discussion and possible action to recommend approval of the criminal conviction guidelines, which is something that one of the work groups has been working on with staff.
Good afternoon, board members. My name is Robert Rennick. I'm one of the prosecutors here at TDLR. For about 9 years, I've been doing pretty much exclusively, well, actually exclusively, criminal history reviews and the filing of denials and NOAVs, notices of alleged violation, to revoke licenses because of criminal histories. I'm sitting here with Chris Russey, who is our research and analytics specialist, who has been dealing with you, Ms. Sensibrian, specifically, and you, Dr. Plummer, and since you two were part of the work group. And Ms. Camp, I guess, is not here today, and that was the third member of the work group. The main reason we're here today is to adopt criminal conviction guidelines, or hopefully see if you are willing to adopt the ones we have drafted and send them on to the commissioners for them to decide whether to adopt them for the agency. And the reason we're doing these so early in the process is because on day one, when the our review of your license or of your industry takes place in October, we're going to be reviewing original applications for licenses and renewal applications for licenses. And at that time, in order to renew those, we have to have guidelines in place for us to decide whether to seek to deny a license or whether to seek to revoke a license. And our agency, maybe not all agencies, but ours, over the years has decided that what works best for us in all of our occupations is what's called Chapter 53 of the Texas Occupation Code, which is a statute that applies to all agencies and all licensees in the state of Texas, and practically. And certainly all occupations at this agency are covered by Chapter 53, or can be. And the reason we're writing guidelines was twofold. One is Chapter 53 requires us to, and it makes sense in a way when you look at someone's criminal history and you want to decide whether to deny their license or to revoke their license for a specific occupation, you have to be able to articulate why this person is a danger or a threat in a particular occupation. And that's why we had the work group meeting on this, and that's why we drafted the guidelines as we have. It's because all the guidelines you have before you, I assume on your computer screens there, are guidelines that we believe are direct, a term I'm going to explain a little bit later, are directly related to your occupation. Now, the other reason, other than Chapter 53 requiring it, is that we want all potential licensees, and certainly people who are renewing, to know what is a crime or that they could be convicted of or have been placed on deferred adjudication for that could be a problem for them in getting a license of this type. So we want the public to be aware if they decide to spend their time and resources in getting the education necessary to perform in this occupation or to keep this license, what crimes they cannot or possibly cannot be convicted of and still engage in this occupation. All right, so let me talk a little bit about the process of how we review applicants. And Ms. Sensibrin and Dr. Plummer, if you'll bear with me, you've heard all this from the work group, but I will try to be brief for the rest of the board. Every applicant, both renewals and original applicants, has their criminal history run. In your program, and it's one of only a few actually, you also have a federal criminal history run, and which entails the taking of fingerprints and submitting that to the FBI for them to review it both on a federal level and other states as far as convictions and or I guess the equivalent of deferred adjudications in other states. When they do that, that is given to originally our licensing division, the results of that criminal history check. And the licensing division will compare the crimes on a particular applicant to the guidelines that are in place. And they will make an initial review. They will only clear a license if it is very old, if a crime that is a guideline conviction is very old, or it's very minor, or it's not within the guidelines. And if there's any question about it, they will refer it to enforcement. And if they do clear it, let's just take one step at a time. If they do decide to clear it, the license will print, at least as far as a criminal history hold. And that's assuming they have all their education requirements done, which other divisions oversee. But there will be no criminal history hold. Let's put it that way, if the licensing individuals who review criminal histories clear the license. If they find that there is something that is questionable, they will refer it to us. And us is the enforcement division. It'll come to either me or to Mr. Ken Sharp, who's sitting over here, who is the other prosecutor who reviews criminal history cases. And then if we seek to deny, Ms. Kaiser, who you've already met, will sign the denial letters. Now, if they send it to us, what we do is we review the same criminal history. And I'll just speak of myself, rather than including Mr. Sharp in every sentence. I'll just speak about it as if it's just me doing it. I will review a criminal history, and I will decide, are these guideline crimes, and are they significant guideline crimes? And that's one thing we always make clear to advisory boards. When they see these guidelines and you just see crimes against a person, well, that could be anything, right? There are a lot of crimes that are crimes against a person. These are not catch-alls that we are just black and white, you're in, you're out, because it's a crime against a person or it's a crime against property in some way. We apply common sense. We apply the obvious factors you would want to apply in a criminal history review, such as the age of the case, the level of the crime, was it a misdemeanor or a felony? If it is a misdemeanor, is it a Class C misdemeanor, in which case Chapter 53 doesn't even apply, or is it a Class B or A, in which case it does? And we take all these factors into consideration. What rehabilitation has the person demonstrated to us, or that we know of? Have they been on probation? Have they been on parole? All those things are, initially we're just going to see the crime. And then we're going to decide, okay, could this be something we might deny for? If it is, I'll do what we call open a case. That means I'll say do not clear. I will fill out a sheet that tells the investigator who is about to be involved in the case, look at these things. And the main things are, tell me exactly what he's been convicted of, he or she, been convicted of or been placed on deferred adjudication for. Criminal histories are notoriously inaccurate, by the way. You may not believe that or know that, but they're incomplete. And the primary job, the first job of the investigator is to tell us exactly which of these things that we're concerned about has actually turned into a conviction or turned into a deferred adjudication. So that's the main thing they give back to us is what this person's criminal history is, both in Texas and in other states. Let me mention one other thing. When the person applies, they are given a criminal history question on the application. So they are asked, have you ever been convicted of or placed on deferred adjudication for any felony or misdemeanor other than a minor traffic violation? They have to answer that question. If they answer that falsely and we ultimately decide to deny them, we will also allege that they were falsified their renewal or their original application. So it's to their benefit greatly to answer that question honestly, although many do not. Probably not as many in your occupation as in some others that we have, but there are people who answer that question falsely quite often. They are also asked on the application, have they ever had been disciplined, suspended or revoked, had a license suspended or revoked by anyone? And they should give us, I was with this board or that board in this state or that state, and I was suspended for this reason or that reason, or I was revoked for this reason or that reason. We take that into account also in deciding whether to deny or to revoke. Okay, so that's all done. I send it to the investigator, or Mr. Sharp does. We also ask the investigator to check if they're on community supervision, commonly called probation. We will ask them to check with their probation officer and see what their status is. Are they complying? Are they not in compliance? Are there any problems? Most of the time, the probation officers will respond to that. Sometimes they won't. Certain counties in Texas won't allow them to respond to that, even with the consent of the applicant, which we always get before we send it to the probation officer. The parole officer, we do the same thing. We get the response from them on whether the person is in compliance. The applicant has the opportunity, if he wants, to send in recommendation letters if he chooses to. He has the opportunity, he is in fact instructed, if he says he has a criminal history, or if we find that he has a criminal history, even though he said no, he's instructed to fill out what's called a criminal history questionnaire, where he tells us all the circumstances of each crime he's either been convicted of or placed on deferred adjudication for. I'm giving you all these details because I want you to know that the applicant has many opportunities to defend himself if we ultimately decide to deny him. And he actually has many more opportunities, which I'm about to go over. So it comes back, the investigation comes back from the investigator to me. I look at it and I make a decision. Either I'm going to clear this guy, in which case the criminal history holds will be removed, and then his license will print, assuming he's met all the other qualifications for the license. If I do not clear the criminal history holds, I will write, if it's an original application, I'll write a denial. If it's a renewal and the person has something that he has done subsequent to the time when his last license was issued and we want to revoke him, then I'll write what's called a notice of alleged violation. If it is if we're seeking to revoke, the burden is on us to prove it when we go to court. If it is an application case, original application case, or really any application, even the application to renew, they have the burden of showing that they are suitable for licensure. That is one other ground we use. We don't normally talk about this too much, but it is applicable, and we put it in every case where we seek to deny. And that is a provision in Chapter 51, which is our enabling statute, that says every license applicant must demonstrate that they have sufficient honesty, trustworthiness, and integrity to hold the license. If we feel they don't, because of the criminal history, we will also allege that ground as a basis to deny the license. So it comes back to me, and I decide to file a denial. I write that up. I send that to Ms. Kaiser. She reviews it, and she will sign it most of the time. If she has questions, she sends it back to me, and then I answer her questions if I can, and then we go from there. But if she signs it and sends it out, the applicant gets that, and it tells him that the department is seeking to deny him. And does he want a hearing? If he wants a hearing, he's entitled to it as long as he requests a hearing in writing. And he has to do that within 20 days of the receiving that letter. Truth of the matter is, we get people who months later request a hearing. We still give it to them if we haven't already cleared the license. We are very flexible on, and many, probably not in your program, but many of the applicants at this agency are not represented by counsel. Some of them don't write well, and we are very flexible, and we interpret anything they say very broadly. If we could in any way interpret it to be requesting a hearing, we give them a hearing. What that means is we set up an administrative hearing at what we have already discussed here today, an agency called the State Office of Administrative Hearings. They have a number of attorneys who have been hired, and they preside over a multitude of hearings that are held by state agencies. License denials is one of the primary ones they do. So we would set it up, say, 2.5, 3 months from the date that we get the request for hearing. And the applicant is given notice. I appear for the hearing with the evidence that we have. Usually that will be certified documents, certified judgments, certified indictments, certified motions to revoke community supervision, certified revocations of community supervision. And we'll appear at the hearing, and we'll be ready to go forward. The applicant should appear. If the applicant does not appear, the case will be dismissed by the SOA judge for what's called for want of prosecution. And they'll still get like 10 to 20 days in order to respond to that and give a reason, if they have one, for not having appeared. So there's another protection or bit of due process that the applicant gets. If they do appear and we have a hearing, the judge will take the evidence from both sides, and the judge will then have 60 days to write what's called a proposal for decision. What that is, in layman's terms, is a recommendation to the Commission of Licensing and Regulation saying, we suggest that you deny this application, or we recommend that you approve this application. They will make findings of fact, and they'll make what are called conclusions of law, which they are proposing that the Commission adopt in an order to be issued by the Commission. Once that PFD is sent, and as I just said, it could go either way, it is set on the next, as soon as possible, it is set on the Commission's next agenda, or on the agenda that is open enough, does not have too many cases to get that case onto it. Usually it's within 2 months of the PFD it will go to hearing. I mean, to the commission's agenda. And then we'll show up and the commission will sit right where you're sitting, and then I will come up and make a presentation when that case is called on that individual applicant. And I'll give the commission all the reasons we're seeking to deny the application. And then the applicant will get the opportunity to sit here, I'll sit down, they'll sit here, and they'll tell the commission what the reasons they think they should get the license. And if it's a revocation, then we tell why we should revoke, he tells why they shouldn't revoke. And then the commission basically votes and decides the case. And that's the end of it, except for the possibility of appeal. And the applicant can file what's called a motion for rehearing, where he says that there was some mistake of law. It's not a mistake over how they decided the facts, but how they applied the law, or whether they were notified if they didn't show up and there was some reason the commission decided on that basis. Or it's a default. A lot of times there's a default, and if it's a notice of a violation where we're seeking to revoke, you don't just dismiss it. You issue what's called a default order. So a judge finds, hopefully, that service was adequate, and then the commission will issue, or the executive director will issue what's called a default order, finding that someone's license should be revoked. And then, but once that's done, the person can file a motion for rehearing saying they didn't get notice, that's why they didn't appear at SOA or answer the original notice of violation. Even after a motion for rehearing, if that's denied, then they can appeal it to district court in Travis County if they choose to. And then they review the commission's order to see if there's some basis for the commission's order. I'm going through this in such excruciating detail because we want you to appreciate how many times and in how many ways an applicant has to defend himself. There is no heavy hand of government just saying, you're out of here. They are given many opportunities. So that brings us to Chapter 53. What types of cases can we deny? And I'm just going to talk about denial right now. But there are four main categories. And the primary one, which is the historic one, is crimes that are directly related to the occupation. Chapter 53 says if you're going to say certain crimes are directly related, then you need to issue guidelines so that the public knows what you're saying is directly related. And that's what we've done. That's what you're going to decide on today. And the agency is instructed to what it means to be directly related basically is a balancing of factors. The primary factor is the criminal history itself. That is the evidence against the person getting the license. The other factors that are the primary factors are rehabilitation evidence, or is rehabilitation evidence. And that is, in an application situation, it is the applicant's burden to show his own rehabilitation evidence. He can do that through recommendation letters, preferably from law enforcement if he can get it, but they often will submit recommendation letters from friends, family, church members, members of their own of the profession who might want to hire them or who know them. They could present letters like that. Letters depending on the type of crime, let's say a sex offender, he would send in very possibly evidence of having had sex offender counseling. They could give us evidence of their probation officer not opposing them getting this particular type of license, or actually hoping that they do and writing a letter in their favor. And anything like that, their age, maybe they were young when they committed the crime and now they're many years older. Their family history, whether they're married now and they were single when they committed the crime, now they have a wife and children to support. Their work history and their church history, they often will provide that. And everything they think the agency will want to know to believe that this person has changed their life. And when the administrative law judge considers all that evidence, he will decide this is directly related or not. What they're really deciding is this person still a threat, although that's not in the statute. But really that's what you're getting at. Is it reasonable to think that this person is still a threat to the people he will encounter or to the property of people he will encounter in this particular occupation? So that's what directly related means. Recently, a few years ago, the legislature added 3 categories that are kind of per se directly related, although it is rare that we will use one of these categories if on just a basic directly related analysis, we couldn't prove the case. Let me give you examples, and I think you'll know what I'm talking about. One new category that's been added is just a reason in and of itself to deny a license are recent crimes. If you've been convicted of a crime that you committed within 5 years of your application, that is a basis to deny your license under Chapter 53. Although we never, I don't want to say never, because we might in the future, I don't know, but we never have denied a license solely on the basis of it being recent. It also has to be within one of these categories, and it has to be within one of these categories in a way where it makes sense to deny it, and where we can convince a 7-person commission to deny it. So we don't just do it based on what I think personally or what Mr. Sharp thinks personally or Ms. Kaiser. It's also what we anticipate the commission is going to think. And so we could do that on just a recent crime, but we don't unless we also think it's directly related, even though the statute doesn't require us to prove that it's directly related as well. The other 2 new categories, one is called, if it is in the list of what are called 3G offenses in the Texas Code of Criminal Procedure. 3G offenses is a list of crimes that are the worst crimes in Texas. Capital murder, murder, aggravated kidnapping, aggravated sexual assault, aggravated robbery, indecency with a child, crimes of sexual assault, crimes like that. If it's one of those types of crimes, then we can deny it for that reason alone. But again, that's almost always directly related. It would certainly be directly related in your occupation. And then the third is crimes of sexually violent offenses as defined in a particular provision of the Texas Code of Criminal Procedure. If you really want to know the provision, it's Article 62.001 of the Texas Code of Criminal Procedure. And that lists a bunch of sex offenses: sexual assault, indecency with a child, aggravated sexual assault, crimes like that. And again, those are not going to be crimes that aren't directly related also, but that's another basis for denying the license. So if you have a conviction in any of those areas, then you can use Chapter 53. The way deferred adjudication is built into that is a deferred adjudication can be a conviction for administrative denial purposes or for Chapter 53 purposes if certain tests are met. If they're still on community supervision and you find that one of 2 questions is true, might they pose a continued threat to public safety, or would their employment in this occupation create a situation where they would have the opportunity to repeat the prohibited conduct? All right, so if either of those are answered yes and they're still on probation, or they're within 5 years of completing probation, or if they're convicted of or on probation for a crime that is listed in the sex offender registry, where they have to register as a sex offender. Those are all the bases of deciding whether a deferred adjudication can be considered a conviction for Chapter 53. Okay, that's a lot of information to give you. So that's what we do, and then we use these guidelines. So one thing that Chapter 53 tells us is you have to set out the types of crimes and the reasons. So that's what we've done. Now, these are very broadly written. The reasons they're so broadly written isn't so we can just say, you're out of here because you somehow fall under this. But we don't want to be in a situation where someone has some odd crime that we haven't, let's say we created a list of crimes that would be a basis to deny. If that list isn't complete, then we get some crime that maybe would be a crime against a person, but we haven't categorized it that way, then we wouldn't be able to deny the person the license. But we want to be able to cover every unanticipated situation by drafting these broadly. All right, you also will see there are crimes against a person, such as homicide, kidnapping, and assault. We are not limiting crimes against the person to those crimes. Those are examples. But there are many others. Robbery can be a crime against a person, just by example. Theft from a person obviously is a crime against a person, and many other crimes. Retaliation, terroristic threat, deadly conduct. These are all crimes that we see all the time. Under these first four categories, all the reasons are identical. And we tried to set out why your occupation, and this is through the very appreciated help of the work group in talking about what you do in your occupation and where you meet with people and what type of people you meet with and work with and what that setting is. So obviously, if you're dealing with, as you read that first sentence, adults, the elderly potentially, the disabled potentially, and children potentially, in situations where you might be alone with those clients, or you might be in a clinical setting or at a school setting, obviously you don't want people who you think are currently violent to hold one of your licenses. And I think we would all agree on that. So I'm hoping. Much of this language, it's identical in the first three categories. And I think it's obvious why we do that. The main thing we're going to be looking out for, I think, in your area is going to be sexual offenses. People of your education level are not, some are going to have some violent crimes. That's not going to be very common, we don't expect. Crimes against the child could occur if they're parents. Most of the crimes involving children, what we're really talking about is a crime called injury to a child. Very often, though, injury to a child is a plea, is what prosecutors will plea sexual assault down to in order to get a plea agreement. So it's a crime we look at closely. So it could be a sex offender who has been convicted of or placed on deferred for crimes for a injury to a child. So it doesn't look like a sex offense, but once you get the police report, which we often ask for in the investigation, and you look at the indictment, then you know this is someone we might need to worry about. So other examples of injury to a child might be spanking too hard, which is you see a lot of, and they get deferred for that. Leaving a child alone at a place where you shouldn't have left them alone, or for an amount of time you shouldn't have left them alone for, that kind of thing. Leave them in a hot car, all kinds of examples that you could think of. But sex offenders are going to be the primary thing we're looking for, and I think that's obvious to everyone, just because of the type of clients or patients you have in your occupation. Crimes against property. It was something we had to discuss with the work group, just because of where you meet with people, and they could have others with them. They could have family members with them, your clients, caregivers with them, friends with them, and there could be purses, there could be wallets, there could be access to the property of those patients and or clients that we would want to protect. And we're not going to, a classic case is you see some guy who, when he was 18, he shoplifted somewhere, or maybe he just stole some tires off of a car. Now he's 28 and he wants a license. We're not going to deny that license to that person. I don't think anyone here would really want us to do that. Let's say he was put on 3 years deferred adjudication, 10 years ago. That's an obvious case of when it falls under the guidelines, but it's not one we're going to be worried about. But if someone has had 3 shoplifting offenses in the last 5 months, we might want to take a look at that. This person obviously has a problem with theft. And so I think we're going to exercise a lot of discretion, and we believe reasonable discretion there. You will see, by the way, who we actually deny or attempt to deny just by watching our commission meetings. Because just because of the numbers, I'm probably presenting to the commission more often than anyone. And second only to me is Mr. Sharp, simply because until recently he was doing only 25% of these cases. Now he's doing 50%, so we should start seeing us an equal number of times. But of all the attorneys who present before the commission, we present the majority of them. So just watch a commission meeting if you want to see who we attempt to deny licenses to. Crimes involving fraud, that's important, we believe, in your industry, mostly because of reason number 4. Everything else is very similar to the others, but if you look at number 4, licensees are potentially involved in the billing of students, clients, and patients, filing of insurance claims, and filing of government documents. You don't want someone in your profession who's been convicted of forgery and credit card abuse in the last 6 months, just to make it obvious, I think, or tampering with a government document or something like that. I don't think you would want that type of person coming into your agency, or if they have Medicaid fraud or something that you find through the national check, which would expose federal offenses. So we would be seeking very likely to keep those people out of your profession. Drugs, simply because of the proximity to your own school settings, you're dealing with children. It's the primary reason we think to be concerned with drugs in your occupation and or profession. This first category, crimes involving the possession with intent to deliver, possession with intent to distribute, delivery, distribution, or manufacture of drugs. We've listed it in all those ways because those are the different ways in different jurisdictions that drug crimes are typically described. For example, possession with intent to distribute, that's a federal method of describing a drug offense. In Texas, you'd call that possession with intent to deliver. We don't use the word distribute in Texas cases. Other states, they could have different names, but that's why we've included just simple possession so that we cover everything that another state might have. As far as plea bargains, a lot of times someone is a drug dealer, but because of whatever reasons in the case, they will plea bargain it down to a possession. You might see 50 pounds of marijuana. You might see possession of 20 grams of cocaine or methamphetamine, and it just says possession. It might have started as a delivery, but good defense attorney, lost witness, maybe a weak witness, whatever, or a search and seizure issue that could be taken up on appeal, they might plead that case to a simple possession. That's why we included possession. Who we're not very likely going to be going after is someone who 3 years ago was driving his car and had a personal use of cocaine, a small amount of cocaine in his car. Now, he's probably going to plead to deferred adjudication to possession of cocaine, completed his probation, fine. We're probably not going to go after that person. But if they have evidence of a drug habit or drug delivery or possession with intent to an amount where they're obviously in the delivery game, but they didn't get caught actually delivering it, then we very, very possibly will go after that person. And that brings us to the last one, which involves drugs as well, but it's more, what we're focusing on there isn't a person who might go into your occupation and try to deal drugs to their clients or to their patients. They possibly could, because you might be establishing a relationship with these individuals you're treating. But the next thing we're worried about is someone who might be under the influence of drugs while performing in your occupation or profession. So if someone has 4 public intoxication cases in the last 3 months, we might not want that person in your occupation until that person has shown that they've cleaned themselves up. They've gone through some sort of therapy and demonstrated that they've changed their life a little bit, and they're not a danger to be drunk on any given day that they are functioning in your profession. Same thing with being on drugs, and that's what this last category is for. All right, does anybody have any questions about anything that I've said so far? And I'm pretty much done.
Hi, this is Patricia Brannon. I wanted to ask you, since we're moving from DSHS to TDLR, will the current licensees have to go back and get fingerprinted again?
They won't be fingerprinted again, is my understanding. If they've already been fingerprinted, we won't do it twice. They will have to apply to renew at some point. I don't know if you're 1 year or 2 year licenses?
2.
2 year licenses. So every 2 years, obviously, they'll have to renew. And let me tell you what we're going to be looking at primarily there is anything they've done since they were most recently licensed. So if the predecessor agency cleared the person, even if it was something we might have denied them for, and they've been functioning perfectly well over a period of years, we're not going to go back and second guess. In most cases, it would be very rare for us to go back and second guess what the predecessor agency did. And if we look at anything when they renew, it's going to be something they've done, most likely, since they got their last license.
Okay, so if they've done something since then and
He got licensed
report-
2 years ago,
the report
and last
comes
month
in.
he got put on deferred adjudication for indecency with a child.
So the report will now go to TDLR rather than DSHS?
The report, the criminal history?
Yes, the criminal.
Yes,
Okay.
yes. And then we will look at it and see what y'all did. Did it occur subsequent to the predecessor agency giving the license, the prior license? And then we will look at it very closely based on our guidelines.
Again, this is Patricia Brannon. So those hits come in all the time, right? From
No, they only come
FBI?
in when you apply, either renew or we don't check them on a periodic basis.
They don't
Every time you
automatically
renew,
come
if they
in.
don't want to renew, they're not going to be checked. So when they renew, though, every time they renew, they'll have a criminal history run. And the fingerprints are already on file, it's my understanding, from the first time that they gave them. So that'll be checked from that basis.
So someone that has just renewed, if they commit something under the influence of alcohol or drugs, that can sit there for 2 years until they renew again?
That is, unless someone files a complaint and lets us know, and we do get that quite often in other occupations. You know, they have a 2-year, let's say it's a cosmetologist, that's a 2-year, or barber, that's a 2-year occupation, or period of time in between renewals. They could, 6 months after they renewed, be put on probation for indecency with a child. We won't know it unless someone tells us until they seek to renew. And that is a
Mary
problem.
Winston, Bob, do we want to talk about a felony conviction or prison time?
Sure.
Okay.
I mean, if they're put in prison, that's a totally different category.
So if they're arrested, you get the arrest, you get something?
We do not get anything
can
until we run a criminal history on them, and we only run the criminal history when they renew. So most of the time, we will not know about it. Even if they're put in prison, we very likely will not know about it until they attempt to renew, unless someone files a complaint. So it's just, you know, we don't have the resources or the manpower to run a criminal history every few weeks on every licensee.
I misunderstood. I honestly thought those came in automatically if they were arrested.
Came into the agency?
Yeah.
No, they do not. Not in any of our other licenses, and I'm assuming not in your occupation as well. I have no reason to think they will in your occupation, and I don't think they will.
This is Sherry Sensory. So just for clarification, Katie Rice is here. Is that any different than what we've had? So did DSHS receive regular reports?
Now,
So that
Katie,
will be a
we're going to
change.
ask you to come up if you
Please
want
come.
to address.
This is Katie Bryce with DSHS, and yes, we do get reports anytime there's a recent arrest of somebody who's currently licensed.
May I ask how you do that? How you get that?
They just come in to us.
You don't know who's sending them? Like, you're
Mm-mm.
arrested out in Tom Green County, and someone sends you notice of them being arrested?
Mhm.
Katie, Mary Winston, what's the frequency of receiving that information?
For the speech board, I may get 2 or 3 a month. And usually they're for misdemeanors, and typically we can't do anything based on it because it's just an arrest. It's not a conviction,
Mhm.
but they do come in.
Good.
Thank you.
Well, we have no access to that, and Oh, okay, all right. All right, apparently, when there is a fingerprint, if it's one of the occupations where fingerprints are requested, I guess the FBI, they must do a periodic check. That's the only thing I can guess, is the method by which they do that. And then they send a notice of arrest to an agency. Most of our occupations are not ones where you get fingerprints, so I've actually never seen that in our agency. But this will be something new. That's great. But as was just said, if there's no conviction or no deferred, we can't suspend them while that case is pending. They get to practice in their occupation until there's a disposition.
And-
Now, if they do go to prison, their license is revoked by operation of law the day they set foot in prison. And it says for a felony, but you really can't go to prison for anything but a felony. So if you go to prison, then your license is revoked by operation of law. But the thing is, you don't know about that. We don't, and unless we start getting notified by the FBI in your occupation, we wouldn't know about that until someone's renews, and then we run the criminal history. But of course, if the FBI sends us notice that someone has gone to prison, then we'll send out what's called a letter advising them of a revocation by operation of law. The letter tells them, this is notifying you that on this day you went to prison, therefore on that day your license was automatically canceled by the operation of law on your license.
And-
So we don't have to take an action.
Bob, Mary Winston, at the end of 2017, I believe, we'll have 32 different boards, I believe, at this time, or programs that we're going to be talking about. Only 4 have fingerprints that are taken. That's why this is new to TDLR. Katie is correct. When we do have fingerprints, then the report will come in. It's a different animal. It's something that, though Bob has dealt with criminal convictions for a long time, we typically don't require fingerprints. Your program does. So whatever DSHS has received federally, we would receive also. But as Katie said, in the 2 or 3 a month that she gets that are arrests, there's nothing that we can do based on our statute and rules with that arrest. That's just not how the law is. But we will have that same information.
The only occupation that I'm aware of that we actually take fingerprints in currently is called staff leasing. And it's a tiny program with individuals, basically companies. And it's going to be directors and/or individuals who own those companies. And there's so few of them, I have never seen a report come in on that. So that's the reason I'm unfamiliar with this, but it's a welcome news to me.
I don't think, Bob, Mary Winston, again, has there ever been disciplinary action in that program? So.
On the denial level?
Not on that, yes. So
Not-
that's something,
Not that I can remember.
yeah, that Bob would not have seen. So,
I'm trying to tell you, this isn't something we see,
It's
and
new.
this is new to us. so
New.
that's
Sure,
great.
since Sabrina, one other thing that may be new is that we have somewhere in our rules, which I don't think changed with the new rules, some provision for emergency suspension, because we do have people who work daily with children, could be in their homes. And if you're arrested for sexual assault of a child, we don't wait for a conviction to take
Okay.
action. So that's in our rules, and it will be something that enforcement needs to take a look at.
Okay. Then we will.
more
Well,
work
Brian,
for the work group.
Also for clarification, you said that the renewals, or the therapists who are going to be renewed, or an audiologist, or will not be asked to get fingerprints again.
Not if they've already been.
Not if they've
fingerprinted.
already been fingerprinted,
Right.
but we'll get the fingerprint, so will the fingerprints, the fact that they already have fingerprints with DSHS, that will carry over to TDLR and those alerts will continue to come? Or only the people who are getting new fingerprints will be able to get those notifications?
I don't know the answer to that, but I'm assuming if we can, we will make an attempt to have them notify us rather than the predecessor agency. But I don't know if that's possible. If that's not possible, then it will only be the new people who give their fingerprints through an application to our agency. I don't have the answer to that, basically.
This is Patricia Brannon. The reason I ask that is that in the past, the departments didn't share that information. And so all the, for example, the licensees that worked in the public schools were required by law to get fingerprinting. Just because they got fingerprinting and it was reported to the schools, they had to go back and get fingerprinted again when the law required licensees to get fingerprinted, because it wasn't an all-reporting system. So the licensees are gonna need to know for sure, the ones that are current licensees, if they have to do that again because we're moving to TDLR.
We'll check into that, but all I can say is that my current understanding is that those who have given their fingerprints to an agency who is regulating them, our predecessor agency or us, will not have to do it a second time.
That would be fantastic.
That's my understanding, so.
Yeah, if we could make that happen, that would be.
Right, I
Good.
understand.
We'd appreciate it, I'm sure. Amy?
Okay, Manny Bodner here. You've covered a lot of ground, and you did a great job covering that ground, and trying to keep up with that. I may take the new comments first and then go back to the first comments, just while
Okay.
it's on my mind. Talking about the fingerprinting, I'm not so sure what the position is on the board with new and old and re-fingerprinting, not fingerprinting. I'd like to hear that discussion, but at some point. But you made a comment that on the ones you take new, then if the old is it DHS?
DSHS.
DHSS. DSHS. If that agency received the information based on the fingerprinting, then you would be receiving that information on new, most likely. Is that an accurate
We're not sure, but
characterization? Not
we are-
sure, but maybe yes, maybe no, okay.
Very possibly.
But then you said, at least I think you said, that if you have the fingerprints already, you're not going to re-fingerprint, based on today's understanding.
If you-
That might change, but you would not have access to those reports. Is that also, did I understand that answer correctly?
The true answer to most of these questions about fingerprints is that we are not completely certain. But I am relatively certain that if we take fingerprints from someone who applies for an original license today, and then we run a check on them and they get licensed, and then 2 years from now they reapply, that they will not have to submit fingerprints again. Now, whether the ones submitted to the predecessor agency are going to be enough for a renewal here without having to give separate fingerprints to us, I think that will be enough, but I can't say that with certainty.
Except what I'm trying to ascertain here is the reports, if a crime has been committed, okay?
Allegedly.
Yes, allegedly. That's very key here.
Yeah.
Okay, so if a crime is allegedly committed, then a report will go in to the current agency, let's say.
I have learned today.
We've just learned that,
Yes.
okay? But from my understanding is, it may or may not, in fact, chances are it will not be coming into this agency. Is that?
Well, that's what
the-
we don't know.
We don't,
Once
so
we
we'll have
take
to
over in
find out.
October,
Okay, we'll have to find out.
we are thinking that they will then advise us, and we will do what we can to ask them to advise us.
Now, they
If
meaning-
there was a method of doing that. But if there is no method of doing that, then we will be at a loss. We will have to then, I would think we'd have to fingerprint them, potentially, if they do not give the notice to us.
Now,
Simply because it was
they is the current agency.
Yes.
Okay. So why would they not share that information?
Just
Just
I
a
don't know if they
rhetorical
would
question.
share it.
Just a
Wendy
rhetorical
Pello,
question.
Assistant General Counsel. I think we're kind of getting off of the criminal conviction guidelines. I think this is something we need to go back and look at, because in terms of what the statute says in terms of applying for new applications, and the statute was also had a provision that addressed renewals, but that provision expired as of February 1st, 2015. And my understanding was, at the time that the fingerprinting was added to the statute, you already had licensees out there but hadn't gone through the fingerprinting process. And so my understanding was that they caught them at renewal, but once everybody got renewed, current licensees, everybody had gone through fingerprinting. I think this is a new twist. We'll need to go back and look at that in terms of how that applies, because our rules were written in terms of new applications. You had fingerprinting at renewal. You just had a criminal history background check, which is running through DPS with name check and whatever follow-up. So that's how it was written. We'll need to do some more investigation in terms of what information can be shared between the agencies, and I'm not prepared to speak in terms of what the law is on that right now, but we'll do some more research and get back to you on that in terms of what we can share, what DSH can share, and if there was an agreement for FBI to share information with them, would they share it with us? Would we need to do an agreement? So I think that's something we can get back to you on.
Well, I appreciate that comment, because that's where I was kind of leading. There has to be some review or examination of where the statute is, where the rules are, and how that can be reconciled. So I do appreciate that comment. Which leads me to an earlier comment that you addressed, insofar as not answering accurately on a new application, on an
Yes.
application. Okay, so there is a question about what your criminal history is. And let's say that goes blank. There is no criminal history, when in fact there is a criminal history.
You mean if they answer it no?
Right. In other words, they say no,
Mhm.
when in fact that there is. So I'll give you two or three, just a couple of examples so you can see where my mind is going. Or they answer the question and say, yes, there is a criminal history in the state of Iowa, just say in another state. And they say what that was, but they fail to mention there's another record in some other third state. So how does that get all reconciled in this agency?
Well, what would happen is, the application itself just asks, on an original application, if you've never had a license, it will ask you, have you ever been convicted of or placed on deferred adjudication for any felony or misdemeanor other than a minor traffic violation? On a renewal application, it will ask, since your most recent license was issued, have you been convicted of or placed on deferred adjudication for any felony or misdemeanor other than a minor traffic violation? If a person answers yes on either one of those types of applications, the application will instruct them to fill out what's called a criminal history questionnaire for every crime that they have that meets the question. For example, on the one since your most recent license, they'll be instructed to fill out a CHQ for everyone since their most recent license. If it's the original application, you'll be asked to fill out a criminal history questionnaire for everything. Okay? Now, is it possible for someone to answer yes, provide us CHQs on Iowa convictions, which our investigators would then check out, but then have Wyoming convictions that they never tell us about and that we don't find out about? Yes, that's possible. But with the fingerprinting, it's unlikely. When that is more applicable are the great majority of our licensees where we don't have fingerprints and we don't check other states and we don't check the federal convictions because we don't have the resources to do it, and we rely on them telling us about them or someone else filing a complaint about them and telling us. But in the fingerprint situation, even if they lie, if they just submit CHQs on Iowa, and we find out through the background check with the fingerprints that they have Wyoming convictions as well, If the convictions in and of themselves rise to the level of what we think that warrant denial, then we will add the language of the falsification allegation to the denial. And certainly if there's that type of falsification, we haven't normally done that, and we probably could. But if we have a good enough criminal history case in and of itself, based on the criminal history itself, we would probably just proceed on that without drawing an extra paragraph in the denial to allege, oh, he said he had convictions in Iowa, but he didn't say he had some in Wyoming, so deny his license because of that
And then
also.
just one more clarification, and that is both for state offense and federal offense?
It's my understanding that the fingerprinting will reveal both federal and convictions in other states. Again, I'm not familiar with it enough because, again, the only time we have it is in a program where we basically have no criminal history. So I'm assuming it does.
Mary Winston, this is another example of why it was good in a way, glass half full, that we did not receive the funding, but we have now, but this has given us time to learn, work on things, work this out. We have work groups to look into enforcement and to answer these questions. We are working from a transition plan that was wonderfully presented by our legislature, but it did not actually cover this. It's always a new wrinkle. So this is something that we have to work out. Wendy and I were just, talking about how, as she presented, we'll have to figure that out. Because it wasn't really considered. But we're still in the process. You're not coming over officially until, we won't be issuing licenses until October 3rd. And until that time, and past that time, we're still going to be working on getting everything lined up. We do want a seamless transition, and that's why Katie's here this afternoon. We had Stuart here this morning. So thanks for that, because it's not we typically don't take the fingerprints. So this is something new. But Christina Kaiser's been doing this for a long time, and whatever we need to adapt to, she's the woman to be out front with that.
This is Kristen Palmer. Do you have any that do have fingerprints now?
A program
that
called
one,
Staff
just that
Leasing.
one, okay.
And it's very small,
Okay.
and we've
Okay.
never had a criminal history denial in connection with that. So I don't, what?
Driver
W-
training.
Yes.
Which is brand new, driver training, which began.
Also, hearing fitters will also have, so we do have programs coming. So this is something that's not unique to, it's rare with the number of programs we have, but there are 3 new programs, include one of which is yours, as well as PEO, which is the Staff Leasing Professional Employment, which we really just haven't had any experience in dealing with it because it's a different type of program. So this is something new, but this is something that enforcement will deal with.
So at this time, do you need the board's recommendation of approval of these guidelines that you presented?
Yeah, most of this criminal history, the fingerprinting thing is separate from the guidelines, so we would ask that you just, if you don't mind, to vote on the guidelines themselves.
So I would entertain a motion to approve these guidelines.
So moved.
Moved by Patricia Brannon, seconded by
I second.
Kristen Plummer. So any discussion about the guidelines that were presented?
I'd like to thank this is Patricia Brannon. I'd like to thank everybody who worked on it.
Thank you. Okay, let's take a vote then. All in favor of approving these recommended guidelines?
Aye.
Any opposed? Any abstentions? Motion carries. Thanks for the work on these. It's good.
Thank you.
Okay, so
Just a question before you leave. Again, for clarification, we voted on the guidelines, and that's good. Are there any cases, or are there any provisions or anticipated provisions for a modification of license? In other words, From my understanding, a license to practice in speech pathology or audiology is either approved, you can practice, or denied, you cannot practice. Are there any provisions for the practice with modifications?
You mean like conditions on it?
Conditions on it, or,
Our- There are two issues that come up all the time before our commission from other occupations. One is called a provisional license, where someone has a history of criminal history, and they know the commission doesn't want to give them a full license. They will ask the commission to give a provisional license. The commission has never done it. The commission's we don't have the framework to do it, and we don't have the resources to supervise that. And so they have either just given the license or not, to date. As far as conditional licenses, or I can tell you the program it comes up with in the most, which is the electrician field. Oh, I only want to work on commercial sites, so my sex offender history should not matter. I'm never going to be around children, and I'm only in, commercial areas. So please give me a license limiting me to commercial sites only and not residences. The commission does not do it. They don't have a method to issue conditional licenses and don't do it. So I don't anticipate they'll do it in your occupation either. Just based on our history.
thank you.
Okay. Thank you for the reports and the work. So, next on the agenda, an update from the work groups, and the first work group was the enforcement work group. And we worked with Mr. Rennick and Mr. Russi on what you just heard by conference call, and thank you for letting us do that. That makes it a lot easier when you live out in far west Texas. So, and we still have other work to do. I'm sure we'll be having more conference calls, no doubt, right, over the summer to plan penalty matrix. Christina? Yes. You've got a...
Good afternoon, advisory board members. I'm Christina Kaiser. I'm the director of the enforcement division. Things on the horizon for the enforcement work group are primarily two things in my mind. One is we want to talk with the work group and about a matter that we discussed a little bit earlier about our process of obtaining the expertise of expert witnesses from the field when we're conducting an investigation. Working out the details of that procedure. For example, if we want to use the advisory board as our initial pool, then by what process does our investigator contact the advisory board, and do we do it on a round-robin basis? All those details of securing the expert testimony when we need it. That's one thing that we'll need to work with the work group about. The other thing is we will need to develop a penalty matrix, and the penalty matrix is used for disciplinary cases as opposed to the licensing cases that you guys have been talking with Bob about today. The disciplinary cases, when a complaint is filed against someone and we find a violation, the penalty matrix will set out the potential administrative penalty or license sanction that the person is subject to for different violations. So that will be quite a bit of work probably, but we will definitely get there.
The other three work groups, as far as I know, unless Mary, you know something different, we have those other three work groups that have not met. The licensing work group to work on licensing rules, which of course we did as a full advisory board, so
Right,
they haven't
right.
really had anything new to add. The education and examination work group, and they haven't had to do anything yet, partly because we use the national exam.
Exactly.
But they may be talking about continuing education rules or something.
None of the other work groups have met yet.
Okay.
Standard of care, of course, we're going to work on at a later date,
Okay.
after the October 3rd date.
Okay.
So I believe that the only work group that has met is the enforcement work.
And for now, with the resignation of Dr. Novak, he was on the education and examination work group and the standard of care, so we'll just expect that the new person will probably fill those slots. And
For now, yes, we'll go with that after we
Contacted.
do another posting and advertising for the position. Yes,
Okay.
we have time.
Okay, good, good. Board members, anything else about the work groups? You have questions or anything you want to add about work groups? The last time we made some notes about potential things that work groups may need to address, but they're not pressing immediate issues, so I think we're okay there. Our next item is recommendations for agenda items for the next board meeting. And at this time, I think they're just things that maybe we've been thinking about as individual board members that I don't know if they'll need to be items on the agenda. But for example, I would like to know more about the communication plan. There are things that we're being asked out in the professional community, like what about, do we have to get fingerprinted again? And that thing that we reviewed last time where people who have a TEA certificate are afraid they all lose their jobs come October 3rd. And so what's the communication plan to get out some of the key points that will be of greatest importance to our licensees? So if we could talk about that.
Definitely, we can add that as an item.
Okay. That's probably the biggest one from me. Manny?
Manny Bodner here. I would be very interested to talk about and understand it's our role in working together with the commission, with the executive director in legislative matters. The legislature is coming up in very shortly, another few months. We'll be in session again. And I'd like to see where our expertise, I think we may have identified a few even this afternoon that may need fixing. Legislatively, then rulemaking, and so on and so forth. So I would like to see that on the next agenda.
Definitely.
What else? Other issues that we want to make sure?
This is Patricia Brannon. It kind of goes along with what you said, Sherry, is and it may fall under communication plan, but I was wondering about, and kind of, to me, falls under technology. I don't think we've talked about it at TDLR. We did talk about it at the DSHS, and it's the people that signed up under DSHS to get emails or notice blasts through DSHS. We did a big drive on that a couple of years ago to get people signed up, or 2 or 3 years ago, so that they get information. If that database is able to be moved over to TDLR, which will help with communication. I don't know.
I do believe, Mary Winston, that it already has been moved over as far as they've been added to our listserv. We did receive their information. We also, aside from the emails, we tried to do social media. We do have that list. That's something we did request.
Good. Okay, good.
We also try to post everything on our website. We have a Facebook page, and we're developing another Facebook page just for health professions, of which you would be on. Twitter, whatever the latest thing will be. I don't think we have Instagram, but not yet.
So the news blast about this meeting, those people that signed up under DSHS should have received
notice. Yes, ma'am.
This is Chevelle Bryant.
Yes.
Mary, I don't know, I think there may be a disconnect with that because I know that I did attend the strategic planning meeting in Houston, and Houston is pretty large. We had 5 SLPs there.
Wow.
And my team of speech pathologists in Houston ISD, I have 160. And when I asked them just last week how many of them are getting emails or getting any kind of communication, I think I had 2 hands that went up. So
we can check on that.
I don't think that went over. I don't
Okay.
think that, I don't know where the disconnect is, but I don't think the communication is happening. the
Mary
way-
Winston, we will work on that because during the strategic planning, I didn't do Houston. I was in Lubbock and different places. Tyler, thank you. We did have some people who received it, some who did not, some from the Gov Delivery. So let us check with our communication people to make sure we have everyone signed up, because we were supposed to, but we have been working on that. During strategic planning, we have been working on it before, and we thought it was more up and running, so we will definitely ensure that, because that's the easiest way to reach the most people. So, yes, thank you.
Any other items for our next board meeting? Other than the regular staff reports and such? Okay. The next item on our agenda is discussion of the date, time, and location of our next board meeting. And at our previous board meeting, we went ahead and set the date and time for the next board meeting. So it is September 23rd at 9 o'clock. And I assume our location is not Hawaii. It's always going to be here, okay. So, all right. So that one's set. Do we need to try to set a meeting following that one, Mary, or are we good for now?
Not at this time. I think we're good for now. At that meeting, we will then know a little bit more, have a little bit more information. We'll be heading towards the October turnover date, and we can go from then.
We're meeting at 9 o'clock. I
Currently.
don't know about the other board members, but this 1 o'clock meeting was great for, as far as travel for me. I don't know about Sherry.
9 o'clock's always risky business because my flight lands at 8:30, so I always hit the ground. I mean, 1 would be great. I was thinking we chose 9 because 1 was already taken, but you might look. Yeah.
We can adjust the date if it works for you guys.
Okay, if that 1 o'clock's not taken, that does make life easier. It certainly is easier for you driving up and everybody driving in, yeah. If that's an option. Oh, yeah, Kristen, that's not nice.
Doesn't appear that there's another meeting on that day.
Well, it'd be great if we could grab the 1 o'clock slot then.
I think that part of that was Dr. Novak was rescheduled.
Oh,
Okay.
okay, so if that's not an issue now, I'm changing
That
it
is
to
a
1.
Friday.
That's a
It's a Friday.
Friday, uh-huh.
There's nothing else on my calendar at this time, so I can give you guys, if there's a problem, I'll reach out to you and get you.
Okay.
So
That'd be
we'll
great.
adjust the time to 1 o'clock.
Good. Thanks for bringing that up, Patty. It does make things easier for sure. So, okay. I think we've covered everything on the agenda, so I would entertain a motion to adjourn.
I move that we adjourn.
Patty Brannon moved, seconded by
Second.
Chevelle Bryan, seconded. All in favor? Aye.